Welcome to the 2020 Richard T. Greener Lecture. I'm Christian Anderson, co-chair of the Greener Memorial Committee, along with Professors Catherine Shattuck and Lydia Brandt. In 1870, 150 years ago, Richard T. Greener became Harvard's first Black graduate. 3 years later, he came to the University of South Carolina as this institution's first Black professor. We commemorated Greener's many contributions to the university with a statue, which was unveiled in the center of campus in 2018. The purpose of the Greener Lecture Series is to discuss some topic that relates to his career or his life or career. In this way, Professor Greener continues to teach us. Randall Kennedy, professor of law at Harvard, will give this year's lecture. He also happens to be a native of Columbia. Yvonne Osirum, who earned her undergraduate and law degrees at Harvard, will talk about Greener's time at Harvard and then introduce Professor Kennedy. She is the current president of the Harvard Black Alumni Association. After Professor Kennedy's talk, Aubrey Gibson, who earned his undergraduate degree at USC and his law degree at the University of Miami, will have a conversation with him. He is a member of the board of the University of South Carolina Black Alumni Council. We are grateful to the Center for Innovation in Higher Education for sponsoring this talk, and to the Museum of Education for hosting it, and to the many others at the University of South Carolina and at Harvard University who have helped to make this event possible. I'll turn it over to you, Yvonne.
Thank you so much, Christian, and good evening, everyone. As Christian said, my name is Yvonne Osirum. I am a graduate of Harvard College and Harvard Law School, and I currently serve as the president of the Harvard Black Alumni Society. It is my great honor to be here today to celebrate Richard Theodore Greener, for whom this year marks the 150th anniversary of his graduation from Harvard College. As many of you know, Richard Greener was the first African American to graduate from Harvard College in 1870. He later became the first Black professor at the University of South Carolina, a law school dean at Howard University, an inspiring writer, orator, and advocate. And throughout the late 19th and early 20th centuries, he was devoted to advancing racial equality. In recognition of Greener's 150th anniversary, I wanted to briefly share some insights into Greener's experience at Harvard. Richard Greener was born in Philadelphia in 1844 and raised in Boston and Cambridge, Massachusetts. On the advice of friends and with the assistance of generous benefactors, he attended secondary school at Phillips Academy at Andover and Oberlin Collegiate Institute before matriculating at Harvard in 1865. In the decades preceding Greener's matriculation at Harvard, the only Blacks on campus were those brought as servants to wealthy undergraduates or employed by the college's janitors or waiters. Greener was not the first, but the second Black student admitted to Harvard College. Tragically, his predecessor, Beverly G. Williams, died before the start of the academic year. And so it was that Greener became the first African American to fulfill the undergraduate curriculum at Harvard and earn a Bachelor of Arts degree from the school. Greener arrived at Harvard as the Civil War was nearing its end. As the only Black student among the 124 college freshmen in his class, and indeed the only Black student on campus, Greener was assigned a single room in College House dormitory, often thought to have been where other disadvantaged students resided. It is likely that in addition to the challenges wrought by the academic rigor of his new college curriculum, Greener experienced some isolation as the sole Black student on campus. In reflecting on his experience in his entry class book, recovered from the Harvard archives, Greener surmised that his fitness for college was inadequate and that he would have to work more diligently than his classmates. He later recalled, however, that he felt confident that he could keep up with his class. By the end of his first semester, then Harvard President Thomas Hill concluded that Greener had arrived at Harvard under the great disadvantages of an inadequate preparation, of having had almost no friends, of being the first student known to have entered this college with African blood in his being. During his first year, Greener began what many may view as an inauspicious start to his career at Harvard. He struggled significantly with mathematics, which was a compulsory course during the freshman year curriculum, and the faculty twice voted either to expel him or otherwise require that he repeat his freshman year. Harvard President Thomas Hill, unwilling to let this social experiment fail, held him back 1 year so that Greener could begin anew. And it was during his second freshman year, from 1866 to 1867, that Greener finally found his footing. He became fast friends with a second Black student who arrived at Harvard that year from Phillips Exeter Academy, and he recalled having seen that friend nearly every day until he left in his junior year. He participated in Harvard's Pi Eta Society and would later serve as vice president of a secret society on campus. In his sophomore year, Greener, for the first time, acquired a roommate, Horace Daming, a friend from Andover, who was then a Harvard freshman. The two roomed together in Stoughton Hall, which is a busy four-story dormitory prominent in kind of the center of Harvard's main yard. They continued to room together through Greener's junior year. In his final year, he roomed with a fellow senior on campus, Oscar Seavey. Greener became a charter member of the student-run Thayer Club, which initially included approximately 150 undergraduates, and which was established to provide meals to needy student diners at $2 a week. When student journalism exploded with the founding of the Harvard Advocate in 1866, Greener contributed short articles and reviews to the publication during his junior and senior years. He won first place in Harvard's Boylston Prize for Elocution competition in 1868, receiving a $50 award. And he would go on to win another Boylston Prize, a second place in 1870, and first place among seniors vying for the Bowdoin Prize in dissertation writing on an assigned subject. His heavily researched essay, The Tenure of Land in Ireland, argued for reform. He branched out socially, attending parties at the start of his senior year. In August of 1869, he also launched a small public speaking career with an appearance at the Institute for Colored Youth in Philadelphia to favorable reviews. During the summer leading into his senior year, he traveled to Rochester, New York to visit his hero, Frederick Douglass, which Greener recalled as an idyllic visit in which the two talked philosophy, history, and politics. Douglass played his violin and recounted his European travels. He confided to Greener that his own long hair was worn in imitation of the great author Alexandre Dumas, whom Douglass had met in France. Greener returned to Harvard for his senior year. As an upperclassman, he participated in informal athletic games and rowing on the Charles River. Though many of Greener's classmates would head to law school, medical school, or move directly into banking or teaching upon graduation, even a Harvard education could not open doors across race. It is perhaps a testament to the punishing reach of racism that, notwithstanding his successful completion of Harvard College, Greener's options upon his graduation were quite limited. Teaching or journalism, confined for him to Black schools or Black newspapers, were the only likely career paths that were remaining. And though he determined to acquire a law degree, after the years that he had spent at Oberlin, Andover, and at Harvard, Greener had substantial debts, and he declined to ask for any further educational funding from the benefactor who had supported his prior educational feats, and so law school would wait. In his May 19, 1870 class book entry, made out at the culmination of his senior year at Harvard, Greener expressed, "My chief desire is to lead a purely literary life in my own way." He would go on, as we know, to serve as professor, a dean. He would devote many years to public service and activism, even taking on his hero, Frederick Douglass, in advocating movement away from political parties and instead organizing a major convention to present Black grievances to the nation. Advocacy, particularly student activism, is at the core of this evening's keynote address. And it is for this reason that I am so delighted to introduce this evening's speaker, Professor Randall Kennedy. Professor Kennedy is the Michael R. Klein Professor of Law at Harvard. He is a prolific and award-winning writer, a thoughtful and provocative speaker, and he has researched and written on civil rights, civil liberties, and the intersection of racial conflict and legal institutions in American life. Professor Kennedy was born in Columbia, South Carolina. He attended St. Albans School, Princeton University, Oxford University, and Yale Law School. He has served as a law clerk for Judge J. Skelly Wright for the United States Court of Appeals and for Justice Thurgood Marshall of the United States Supreme Court. Awarded the 1998 Robert F. Kennedy Book Award for Race, Crime, and the Law, Professor Kennedy has contributed to a range of scholarly and general interest publications. It is now my great pleasure to turn this evening's discussion over to you, Professor Kennedy.
Thank you very much for that generous introduction. And I'm so flattered, I'm so honored to be here as a participant in this lecture series. I'm especially happy to be with this audience in as much as it's largely a South Carolina audience. I'm from South Carolina. I'm from Columbia. I was born in 1954. And I've maintained very close connections with my home state of South Carolina. You'll notice my palmetto tie. I have relatives with whom I'm very close who live in South Carolina, and I visit when I can. Some of you may know my cousins. One of my cousins is James Price, very distinguished principal for many years. Another one of my cousins, Gary Bell, CPA. Another one of my cousins is Dr. Thaddeus Bell, physician. These are folks who have been with me all my life, have provided much encouragement, and it's one of the reasons why I think of South Carolina with great fondness. My talk this evening is going to be about the way in which the struggle for racial justice in America has bequeathed to the United States many benefits in many domains of social life. One of those benefits, of course, comes from the challenge to one of the great evils in American life, racism. But the struggle against racism has had many other sorts of consequences. If you think about the way in which the struggle against racism has influenced the struggle for feminism, or the struggle for gay liberation, or the struggle for work people's rights, laboring rights, organized labor in particular. In all of those domains, if you do just a little bit of scratching, you will see the way in which the struggle for racial justice has inspired, has influenced, has nurtured all of these other struggles for social justice. Another way in which the struggle for racial equality in American life has had a beneficent influence is because of the way in which it's affected the boundaries of freedom of expression. To protect members of the National Association for the Advancement of Colored People from damaging exposure by those who wanted to destroy the organization, activists moved courts to recognize organizational privacy. The big case there was NAACP versus Alabama. To shield civil rights attorneys from rules that would have crippled their ability to further their cause through lawsuits, advocates nudged the courts to acknowledge litigation as a form of political expression, warranting protection under the First Amendment. Big case there was a case called NAACP versus Button. To insulate news organizations from officials who loathe publicity that put racial segregation in a bad light, lawyers convinced the Supreme Court to transform the law of libel. The big case was New York Times versus Sullivan. To protect civil rights protesters against hostile authorities, advocates persuaded courts to craft rules that inhibited the squelching of mass dissent. One of the big cases there was a case right from Columbia, South Carolina, Edwards versus South Carolina. The lawyer representing the dissidents in that case was the great Matthew Perry. Student activists have contributed mightily to this dual campaign for racial justice and enhanced liberties. A seminal confrontation that really pushed this campaign forward stemmed from events on February 25th, 1960, when 29 students enrolled at the all-Black Alabama State College participated in a sit-in. Their target was a racially segregated grill located in the county courthouse in Montgomery. Their protest occasioned neither violence nor arrests. Still, when the governor of the state, John Patterson, heard about the demonstration, he advised the African-American president of Alabama State, H. Council Trenholm, to consider expelling the participants. As governor, Patterson was the ex officio chair of the State Board of Education. His advice therefore mattered greatly to President Trenholm. On March 4th, after additional demonstrations and after having personally warned dissidents to desist, President Trenholm sent letters to 9 students informing them that they had been expelled for conduct prejudicial to the school and for conduct unbecoming a student or future teacher in schools in Alabama, for insubordination and insurrection, or for inciting other pupils to like conduct. 6 of the students challenged the legality of the expulsions in a case called St. John Dixon versus Alabama State Board of Education. Their attorneys, a distinguished array that eventually included Thurgood Marshall, Jack Greenberg, Fred Gray, and Derek Bell, argued that the punishment violated the federal constitution. They mainly focus on the absence of any notice or hearing at which the students could contest the authorities' allegations. The federal trial judge presiding over the case was Frank Johnson, a white Alabamian who later distinguished himself by safeguarding the rights of anti-racist protesters. On this occasion, however, he ruled against them. First, he maintained that the right to attend a public college or university is not in and of itself a constitutional right. Second, he posited that the right to attend is conditioned upon an individual student's compliance with the rules and regulations of the institution. A regulation imposed by the Alabama Board of Education declared that just as a student may choose to withdraw from a particular college at any time for any personally determined reason, the college may also at any time decline to continue to accept responsibility for the supervision and service to any student with whom the relationship becomes unpleasant and difficult. A related provision stipulated that acts of insubordination, defiance of authority, and conduct prejudicial to discipline and the welfare of the school will constitute grounds for suspension or expulsion. Judge Johnson saw these terms as having the effect of reserving to the college the right to dismiss students at any time for any reason without divulging its reason other than it being for the general benefit of the institution. A splintered panel of the Fifth Circuit Court of Appeals reversed Judge Johnson. Constituting the majority was Judge John Minor Wisdom, the most staunchly liberal of the judges on that court, and Judge Richard Taylor Reeves, another strong liberal who wrote the opinion. Judge Ben F. Cameron, a fervent segregationist, dissented. The question for decision, Judge Reeves declared, was whether the students had a right to any notice or hearing whatever before being expelled. He and Judge Wisdom concluded that they did. Reeves gave short shrift to the right privilege distinction invoked by Judge Johnson, declaring that even if a person has no constitutional right to pursue a given activity, he does have a right to be free of governmental interference unless it is constrained by due process. The Court of Appeals similarly dismissed the argument that the plaintiffs had waived their rights by matriculating at Alabama State upon terms to which they had agreed. The state, Judge Reeves declared, cannot condition the granting of even a privilege upon the renunciation of the constitutional right to procedural due process. Judge Cameron groused in dissent that the court's decision would undercut school authority, subvert student discipline, and make federal functionaries, I suppose he meant judges, into a gargantuan aggregation of wet nurses or babysitters. Judges Wisdom and Reeves insisted, however, that under the federal constitution, the student protesters were entitled to due process, and under the circumstances, due process required notice and some opportunity for a hearing, prior to the expulsion for misconduct. The Dixon decision broke with a deeply ingrained judicial tradition of deference to school authorities. Judge Reeves sought to obscure the novelty of what he and Judge Wisdom had done. Their innovativeness, however, is highlighted by a ruling announced by another federal court of appeals 5 months prior to the protests that triggered the Dixon expulsions. Steyer versus New York State Education Commissioner involved a student who wrote letters to the president of Brooklyn College complaining that the school's administration was wrongly dominating student organizations. This student was suspended for 6 months under a rule requiring students to conform to the requirements of good manners and good morals. After being readmitted and agreeing to have a change of spirit, Steyer cooperated with publicizing the news of his suspension and probation in the college newspaper. For this, he was expelled. Responding to Steyer's assertion of a federal constitutional grievance, federal courts concluded that he had no valid claim. One judge quipped that while the plaintiff was indeed constitutionally free to say what he pleased, he was not entitled to say it as a student at Brooklyn College. After all, the judge reasoned, the student had been admitted not as a matter of right, but as a matter of grace, having agreed to conform to the school's rules and regulations. Steyer was no outlier. When it was decided federal case law permitted students to be disciplined, even expelled, on virtually whatever terms the school officials determined. It is against that backdrop that the Dixon case is rightly seen as a pioneering ruling. Sociologically, Dixon highlighted the peculiar position of the Black college president in the age of segregation. On the one hand, Black college presidents exercised powers that were rare for any African American to experience in Jim Crow America, especially in the South. Black college presidents oversaw workforces, dictated the fates of professors and students, associated with some of the nation's most affluent people, and knew, sometimes quite familiarly, major regional and national politicians. At the same time, the all-white boards of education and boards of trustees that selected and supervised Black college presidents typically communicated the expectation that these educators would toe the segregationist line on racial politics, or at least prevent open rebellion on campus. Trapped by dependency on whites for financing and other essential resources, Black college presidents were victimized by many of the same aggravating racial humiliations visited routinely upon ordinary Negroes. Although to students and peers in the world of the Black college, President Trenholm was a formidable figure, to the governor and other white officials, he was but another boy from whom they could and did demand obedience. When Governor Patterson got fed up with the desegregationist dissent of Lawrence H. Reddick, the chair of the history department at Alabama State College, the governor denounced the professor on television as a communist sympathizer and racial agitator whom President Trenholm should dismiss before sundown. Trenholm dismissed Reddick just as he expelled the dissident students. Many observers faulted President Trenholm for failing to do more to resist the segregationists. It is indeed unfortunate, wrote a correspondent from Chicago, that you have become the hatchet man for the governor of Alabama and expelled those kids. Someone from Philadelphia complained that the Uncle Toms are supposed to be dead. Does economic security mean so much? How will you face tomorrow? An observer from Huntsville, Alabama declared, "We must not jump every time the white man speaks." Writing from Dayton, Ohio, Trenholm's own cousin remarked, "You should have resigned yourself." Many students, however, recognized Trenholm's vulnerable position and the agonizing compromises that attended it. The same day that Trenholm warned activists to desist from further protests, one of them sent a remarkable petition addressed to the governor, the figure whom they correctly saw as the real power behind the repression. This student, Bernard Lee, was expelled, became a plaintiff in the Dixon case, and subsequently emerged as a key aide to Martin Luther King Jr. Lee's petition reflects the idealism, poise, and boldness that suffused the sit-in movement of the early 1960s. This is what Bernard Lee wrote. To the Honorable Governor John Patterson, we have taken cognizance of your mandate to President Trenholm to dismiss from the school those students who participated in the sit-down strike at the county courthouse, snack bar, Thursday, February 25th, 1960. We, a united group of students at said college, humbly request that you reconsider your order to President Trenholm. This decision is out of tune with the spirit of Americanism. The snack bar at the courthouse is a symbol of injustice to a part of the citizens of Montgomery. It is a flagrant contradiction of the Christian and democratic ideals of our nation. We went to the snack bar not as hoodlums, but in the same manner and spirit in which other college students have done in other parts of the country. Our purpose was to express our resentment of a scheme that fails to recognize its responsibility to decent and orderly persons of all creeds, color, or nationalities. Our cause is just. We are asking that you study it with an open mind and give President Trenholm the authority to settle this issue with us. We are reasonable and considerate. We may be crushed, but we shall not bow to tyranny. Although Lee and the other expelled students won their lawsuit, none of them re-enrolled. Eventually, though, their sacrifice did receive a bit of recognition. In 2010, Alabama State University reinstated the 9 and conferred upon them honorary degrees. Dixon involved college students. What about federal constitutional rights for high school students? The most famous case recognizing a right to freedom of expression for high school students is Tinker versus Des Moines District, decided by the Supreme Court in 1969. In Tinker, a principal suspended junior high school students who refused to remove black armbands symbolizing protests against the Vietnam War. Noting the absence of any evidence that the student symbolic protests caused any disruption or posed a threat of substantially interfering with the work of the school, the Supreme Court ruled that the principal had violated the young dissident's First Amendment rights. Writing for the court, Justice Abe Fortas declared that neither students nor teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. As is usual, however, the judgment of the Supreme Court represented a ratification rather than the initiation of a legal proposition. As Justice Fortas acknowledged, courts in the Deep South had previously grappled with the issue of constitutionally protected rights of freedom of expression for secondary school students. In one of these key disputes, Burnside versus Byers, the black principal of the black Booker T. Washington High School in Philadelphia, Mississippi, forbade students from wearing freedom buttons to school. Emblazoned on these buttons were "One Man, One Vote" and SNCC, standing, of course, for the Student Nonviolent Coordinating Committee. Students who refused to remove the buttons were suspended. 3 challenged the constitutionality of this punishment. They argued that it wrongfully encroached upon constitutionally protected freedom of speech. The state contended that the prohibition should be permitted under the circumstances because it assisted in the maintenance of proper discipline. Allowing students to wear political buttons would inevitably result in distraction, thereby undercutting the school's educational mission. The plaintiffs lost the first round when a United States district judge declined to issue a preliminary injunction against the suspension. On appeal, however, the plaintiffs prevailed. In the Burnside decision, the Fifth Circuit Court of Appeals bestowed upon high school students a right protected by the First Amendment to express themselves unobtrusively, even against the wishes of school authorities. The Fifth Circuit thus anticipated by 3 years the Supreme Court's Tinker decision. A third case that I want to discuss stems from events right here in South Carolina. They stem from events at South Carolina State College in Orangeburg. South Carolina, in this case, we had a very interesting controversy that revealed an especially protracted episode of intra-racial conflict over civil liberties. The president of the college was Benner C. Turner. Born into an affluent family in Columbus, Georgia, Turner attended Phillips Exeter Academy in Andover, Massachusetts, before attending Harvard College and Harvard Law School. He served as the dean of the South Carolina State Law School before being selected in 1950 as the president of South Carolina State College by Governor Strom Thurmond and an all-white board of trustees. Like other African-American presidents of Black segregated public institutions, Turner occupied a precarious position. He served at the pleasure of a political regime committed to the maintenance of white supremacy. Annually, he had to beg an all-white segregationist legislature for funding. He had to wrest support from lawmakers who openly and unapologetically favored white schools over Black schools. He had to contend with influential arbiters of white public opinion who maintained that under segregation, race relations were harmonious and that Blacks ought to be satisfied with what they had received. The Negro, the Times and Democrat newspaper announced in August 1955, has much for which to thank the white race. He has been given through public monies a splendid educational establishment in this state. Under Turner, South Carolina State gained important educational accreditation. He oversaw the building of dormitories, housing for faculty, classroom facilities, a football stadium, and the elevation of faculty salaries and qualifications. In 1950, only 2 members of the faculty had earned doctorates. By 1967, the number had risen to 27. At the same time, Turner ran South Carolina State autocratically. According to historian William C. Hine, he segregated himself from most Black people. He had little interest in social activities. He took no part in church, lodge, or fraternity affairs. To some people, he resembled the overseer of a plantation. The suppression of students and employees of the college, including professors, was a salient feature of Turner's rule. Some contend that his authoritarianism should be understood as a technique that he perceived as needed to protect his institution. He sought, it can be argued, to preempt white extremists who were all too eager to shutter the school by seizing upon provocations that would alienate white segregationists. There is something to that defense. Turner undoubtedly viewed cracking down on anti-segregationist dissent as a price worth paying for the survival of an institution that contributed significantly to the advancement of Blacks in South Carolina. It would be unrealistic, however, to portray Turner's dictatorial ways as stratagems focused solely on the well-being of the college. Turner liked exercising power and disliked being contradicted by those he viewed as subordinates. He suppressed dissidents not only because he saw them as threats to his institution, he suppressed them too because he abhorred being challenged, especially by other Black people. In 1956, when the student government president, Fred H. Moore, called a strike to protest against threats to send law enforcement personnel onto campus to quell anti-segregationist activism, Turner, with the Board of Trustees, retaliated harshly. He expelled Moore summarily and notified 14 other students that they would be excluded from campus after the end of the school year. Several professors were also sent packing, including the faculty advisor to the student newspaper. Her offense? She had failed, in Turner's view, to be sufficiently rigorous in excluding from the newspaper objectionable commentary. Turner took decisive steps to foreclose that from happening again. He put into his own hands the authority to pre-clear what was published. While it is not forbidden that comments on controversial matters be printed in the college paper, he announced, final authority as to what shall be printed must rest in the president's office and not in the faculty advisor. On February 24th, 1967, 3 students, Joseph Hammond, John Stroman, and Benjamin F. Bryant Jr., received notice that college officials had suspended them for 3 years for having violated College Regulation 1. The student body is not to celebrate, parade, or demonstrate on the campus at any time without the approval of the office of the president. An unauthorized protest had voiced disapproval of Turner's dictatorial streak. Previously, his censorship had been resented but not legally challenged. This time, students took South Carolina State College to court and prevailed. Striking down Regulation 1 as an illicit prior restraint on speech and assembly, United States District Judge Robert Hemphill maintained that academic progress and academic freedom demand their share of constitutional protection. 3 months later, President Turner resigned. Because of the efforts of activists who demanded rights to due process and freedom of expression as they fought to dismantle Jim Crow pigmentocracy, all students and all teachers at public institutions came to enjoy an elevated legal status. In 1950, they had been subject to the dictates of authorities uninhibited by federal constitutional restraints. By 1970, they had won judicially recognized rights. Here as elsewhere, brave souls committed to battling racial oppression widen the circle of freedom to which all in America can properly lay claim. Thank you very much for listening to me.
Thank you, Professor Kennedy. We really appreciate you, your remarks tonight. Honestly, I think we all learned a lot about Black student activism and just the role they play within our legal system. So thank you again for taking the time this evening to have this discussion with us. We have a number of questions for you if you're still available.
Absolutely.
I'd love to ask you. Okay, perfect. Considering the role that Black activism played in our legal system, let's imagine if Professor Greener dropped into the 1960s during this time, during your discussion, and all the different types of Black student and legal activism that occurred there. How do you think he would have reacted or just played a role in those different types, during those different times in his life? So as a student at Harvard and then as an educator down at University of South Carolina?
Well, I think that Richard Greener would have joined the splendid ranks of student activists, student dissidents. I can imagine Richard Greener, if if we could sort of do some time travel, Richard Greener would have been arm in arm with John Lewis and Julian Bond and Stokely Carmichael and Cleveland Sellers. He would have been arm in arm with them. We in the 19th century, he was a participant in the struggle for social justice. In the 20th century, he would have been a participant in the struggle for social justice.
Okay. And how do you think, I'm guessing, as an educator, we all know he was the first Black professor at the University of South Carolina. What do you think his role would have been possibly in the 60s there? Do you think he would have advocated or supported the students in their efforts?
Oh, absolutely. Again, I think that he would have been a friend and a comrade of these other dissidents who pried open the opportunities that have benefited me for all my life, and that benefit you, and that benefit so many, and that in fact, benefit the United States of America. The fact of the matter is that these young people who engaged in heroic, disciplined, intelligent, collective action, they made the United States better for all people, not just African American people, all American people. And not just, in fact, their influence goes beyond that. Their influence is an international influence. We see people in every part of the globe who sing songs, who use slogans, who use ideas that were generated by just the sort of young people about whom I spoke a few minutes ago. So these people didn't just change American history for the better, they changed world history for the better. And again, I think that, if Greener would have been part of that tradition, and indeed Greener was part of that tradition, because these students, they didn't just come out of nowhere. These students tapped into a tradition. They carried on a tradition. What was the tradition they carried on? They carried on the tradition of Frederick Douglass and Richard Greener and others as well.
No, you're right. You're right. Thank you. You mentioned a few times, so in 2010, the Alabama State students were given honorary degrees. Other sorts of similar acts have happened in recent years. So in 1961, the convention, the convictions of the Friendship Nine of Rock Hill were overturned. They were, and they issued apologies for that in 2015. Last year, the 14 Black players kicked off the Wyoming football team were given honorary degrees. And an apology was issued. Do you think these types of acts are sufficient to overcome any type of racism or any other issues at the schools or bad history? And if not, what else do you think is needed?
Well, are they sufficient? No, they're not sufficient. They are good. I don't want to minimize them. I think that these actions are good, very good. We are reckoning with our history. We are appreciating the wrongs that have been done. There are efforts afoot to rectify those wrongs. The rectification is going to have to take lots of different forms. Some of the rectification will be symbolic, and symbolic rectification is very important, very important. I mentioned, at the beginning of my talk, I mentioned the great Matthew Perry, who was the lawyer for the students who were arrested in the case that became Edwards versus South Carolina. It means a lot that when you go to the federal courthouse in Columbia, South Carolina, you go to the Matthew Perry Courthouse. That's quite meaningful.
Yeah.
And I think that the various episodes that you mentioned, in which there is a revisiting of these episodes, a rethinking of these episodes, the giving of apologies, the giving of honorary degrees, that's deeply important. You know, in Martin Luther King Jr.'s letter from a Birmingham jail, Martin Luther King, in Letter from a Birmingham Jail, said at one point in the letter, he said, there will come a time when the real history of the South is written. When the real history of the South is written. And he talked about the heroes that would be raised up. He said, you know, when he's writing this letter, no one's people are not recognizing them as heroes. But at a point further down the road, they would be recognized for their heroism. Well, that is happening little by little. And I'm happy to see that. And by the way, before I know we don't have all night, but while I've got the floor, I want to say again, I'm very honored to be part of this series. I'm very honored to be part of this audience. And one of the reasons why I feel so honored is because over the course of my time, I've learned so much from journalists, intellectuals, scholars who have focused on the history of South Carolina, particularly the racial history of South Carolina. And in fact, I think my own view is that the participants in this history making have not gotten the attention and the applause that they deserve. So I'm going to mention some names because these are people who I use a lot. I've read their work and I've reread their work. I study their work. I'm thinking of W. Lewis Burke, professor at University of South Carolina Law School for a good long time. Patricia Sullivan. I mean, I've read Patricia Sullivan's wonderful book on the NAACP a couple of times. Orville Vernon Burton, Armand Durfner, Jack Bass, Peter Lau, William C. Hine, and Bobby Donaldson, who's right there with you. Bobby Donaldson. I mean, the last time I was in Columbia, it took me on a wonderful tour downtown Columbia, South Carolina, pointing out the various places where people had engaged in sit-ins. So, you know, I think what we have to remember is that it's history is created in a variety of ways. There are the people who do things, like the students that I applauded a few moments ago. History is also created through events like this one tonight, because we have to remember what was done. That the memory of what was done is part of history as well.
No, Professor Kennedy, honestly, I think we should probably conclude with that. Because like you mentioned, I think it's really important to remember the heroes and to continue just talking about them and discussing them. So again, we really want to thank you for taking the time here and to handle our Richard Greener lecture this year. We want to thank Harvard Law School, Professor Kennedy. Again, we want to thank Yvonne and the Harvard Black Alumni Society, Professor Anderson, the Richard Greener Committee, and the University of South Carolina Black Alumni Council. So again, Professor Kennedy, we really appreciate you taking the time to speak with us tonight.
Thank you very much.
Appreciate it. Have a good night.
Thank you.